Honorable Vice Chancellor Shri Professor Nageshwar Rao sir, our Chief Guest Honorable Central Information Commissioner New Delhi Shri Suresh Chadha sir, Professor Satyakamji sir, Pro Vice Chancellor, Professor Dr. Shrikant Mohapatra ma'am, Pro Vice Chancellor, Professor Uma Kandilal ma'am, Pro Vice Chancellor, Professor Sumitra Pukriti ma'am, Pro Vice Chancellor, Dr. Alok Chaubey sir, Registrar, Dr. Sunil Srivastav, Director, School of Law, Directors of Schools and Heads of Division, Regional Directors, and all the teachers, faculty members, PIOs of IGNOU, and all those who are watching us through medium of Facebook, YouTube, or Zoom link. I warmly welcome you all here. A very good morning. I am Meera Rizvi, Research Scholar, School of Law, and on behalf of School of Law, I welcome you in today's program that is conducted by our school. Today, we all are gathered here to celebrate the Constitution Day, which is observed in our country on 26th of November each year to commemorate the adoption of the Constitution of India. Since 26th will be a Saturday and it's a holiday for IGNOU, so we will celebrate it today. Well, I would not take a lot of time of yours, but before I invite our Director, School of Law, I would like to quote Honorable Prime Minister here. He said our Constitution is a ray of hope, where H stands for harmony, O for opportunity, P for people's participation, and E for equality. With this thought in mind, we would start our program. I would request Honorable Vice Chancellor sir to facilitate our Honorable Chief Guest by presenting a shawl to him. I would humbly request Honorable Vice Chancellor to present the spot to our guest. Welcome. I would request Dr. Sunil Srivastav ma'am present the spot to Professor Satyakamji sir, Pro Vice Chancellor. Sorry, I'm so sorry. To our Vice Chancellor, Professor Nageshwar Rao sir. Please pardon me if I commit some mistake.
बस हो गया अब हो गया और देने की जरूरत नहीं आगे बढ़िए
I would request Mansi ma'am to present the pot to Uma Kandilal ma'am.
अब आगे आगे बढ़ो पॉट वाला आगे
I request Honorable Vice Chancellor sir and our Chief Guest, our Pro Vice Chancellor and Directors of light the traditional lamp and inaugurate the program. Now I would request Dr. Sunil Srivastava, Director, School of Law. Ma'am, please come on the dais and deliver the welcome address.
Vice Chancellor, Professor Navishwar Raoji, Honorable Information Commissioner, including Chandra, Chief Guest of today's event, Pro Vice Chancellor Satyakamji, Pro Vice Chancellor Uma Kanjilalan, Pro Vice Chancellor Dr. Shrikant Mahapatra, Pro Vice Chancellor Professor Sumitra Pukriti Ma'am, Registrar Admin Dr. Alok Chaubey, Directors of Schools, Heads of Division, Center, Units and Regional Centers, PIOs from different divisions, teachers, staff, ladies and gentlemen. It is indeed my pleasure to welcome you all on behalf of IGNOU School of Law on this auspicious occasion. Constitution Day, also known as Samvidhan Divas, is celebrated in our country on 26 November every year to commemorate the adoption of the Constitution of India. As we all are aware that on 26 November 1949, the Constituent Assembly of India adopted the Constitution of India, which came into effect from 26 January 1960. The Ministry of Social Justice and Empowerment on 19 November 2015 notified the decision of the Government of India to celebrate the 26th day of November every year as Constitution Day to promote constitutional values among citizens. Since 2015, 26 November Constitution Day has been marked with great enthusiasm by people across the nation, a proud occasion for every countryman. It celebrates the spirit and strength of a democracy. As has been rightly said by our Honorable Prime Minister, Shri Narendra Modi ji, our Constitution is an outcome of extensive discussion and timeless effort of the Constituent Assembly and is the essence of the collective wisdom and experience of illustrious members of the Assembly. The Constitution is a rich social document. It contains the dreams that our freedom fighters had for the nation. The Constitution is the means through which the dreams and aspirations of the people can be fulfilled. The Constitution Day celebrations during Amrit Mahotsav of Independence inspire all of us to rededicate ourselves to the values enshrined in our Constitution. Our Constitution begins with "We the people of India," with the spirit of collectivism and mantra of Sabka Saath. Let us strive that we the people are the Constitution's strength as well as purpose, and it remains engaged in the new generation. With that note, I once again welcome all of you to this event. Thank you.
Now, I would request everybody to kindly raise for the reading.
यह जन जन का विश्वविद्यालय
नहीं यार
इसलिए लैपटॉप लैपटॉप भी चला दीजिए। डायरेक्ट ऑडियो फाइल चला
विश्वविद्यालय यह जन जन का विश्वविद्यालय सरल सुगम शिक्षा का आलय जन जन का विश्वविद्यालय जन जन का विश्वविद्यालय ज्योत जलाई ज्ञान की स्वाध्याय की अनुसंधान की राह दिखाए वंचितों को शिक्षा के अधिकार की ना उम्र का कोई बंधन ना बंदिश खरीदी की घर घर है बना शिक्षा का देवालय यह जन जन का विश्वविद्यालय जन जन का विश्वविद्यालय
जन जन का मान है सम्मान है पहचान है
जन जन का मान सम्मान पहचान है
राष्ट्र का मान है अभिमान है अभिमान है
राष्ट्र का मान वरदान अभिमान है सर्वसुलभ सर्वोत्तम शिक्षा का निर्माण मुक्त और दूरस्थ शिक्षा का महान यह जन जन का विश्वविद्यालय जन जन का विश्वविद्यालय देश विदेश पटल पर भूषित नवाचार से सज्जित गुणवत्ता से परिपूरित ज्ञानवाणी ज्ञान दर्शन ज्ञान कोश से संचित ज्ञान कोश से संचित सर्वगुण संपन्न शिक्षा का हिमालय शिक्षा का हिमालय यह जन जन का विश्वविद्यालय जन जन का विश्वविद्यालय
Thank you. Now, I will request Honorable Vice Chancellor Professor Nageshwar Rao sir to deliver the oath and to all our guests to raise for the oath taking ceremony.
हम भारत के लोग भारत को एक संपूर्ण प्रभुत्व संपन्न समाजवादी पंथ निरपेक्ष लोकतंत्रात्मक गणराज्य बनाने के लिए तथा उसके समस्त नागरिकों को सामाजिक आर्थिक और राजनीतिक न्याय विचार अभिव्यक्ति विश्वास धर्म और उपासना की स्वतंत्रता प्रतिष्ठा और अवसर की समता प्राप्त कराने के लिए तथा उन सब में व्यक्ति की गरिमा और राष्ट्र की एकता और अखंडता सुनिश्चित करने वाली बंधुता बढ़ाने के लिए दृढ़ संकल्प होकर अपनी इस संविधान सभा में आज तारीख 26
नवंबर
को एतद द्वारा इस संविधान को अंगीकृत अधिनियमित और आत्मार्पित करते हैं।
I would please request for each one for now. 50 introducers for honorable chief guest.
Very thankful, sir, that you have raised this occasion. P. Suresh Chandra Ji, Honorable Information Commissioner, prior to joining as Information Commissioner, has also served as, on various important posts. He was the Union Law Secretary during 2016 to 2018. He served as Additional Secretary in the Main Secretariat of Ministry of Law and Justice. He was legal advisor to Ministry of Railways, Ministry of Defence, Ministry of Labour, National Airport Authority. He also served as OFD and Secretary to the Law Minister, late Shri Jaitley Ji. For his outstanding services and contribution in the field of law, he has been conferred various awards and certificates, including ICQE SMS 2007 Excellence Award by the Honorable Minister of Labour and Employment, Cabinet Secretariat Award for creating and implementing Sevottam Competent Citizen Clients Charter, National Law Day Award 2016, SKOCH Award for implementing LIM, Digital Monitoring of courts cases through legal information management, and many more. With that note, I invite our chief guest for the lecture. Please, sir. Would you like to sit, sir? Because you have the people to you.
वहां से हो जाएगा।
Awards operate from there. Sir, then he will operate from there.
वो करेंगे आप बोलिए सर।
Actually, Zoom link chat.
नहीं तो आपका
एक मिनट उसमें शेयर करो और स्लाइड चेंज कर लो सब दस
मुझे स्लाइड से सर कैसे दिखेगा उधर तो फिर मुझे वहां पे
Professor Nageshwar Rao ji, Honorable Vice Chairman, IGNOU, Pro Vice Chancellor, Professor Satyakam ji, all other Pro Vice, Dr. Sunil Kumar Srivastava ji, Dr. Arun Chaudhary ji, all guests, faculty members, PIOs, and ladies and gentlemen. It is a proud privilege to be part of the deliberation, especially during the Azadi Ka Amrit Mahotsav, to discuss or to deliberate upon a very important topic, that is right to information, a constitutional perspective. As the university is celebrating constitutional law day, it is also very important that we discuss this topic, which is very close to our heart and very relevant to the common people. While discussing the topic, we will cover the right to information and the constitutional relevancy, or can say the viewpoint from a constitutional angle about the right to information. When I was dwelling upon as to whether I should discuss was the Constitution of India or the right to information, I was wondering, if I start with the Constitution of India, I will go in oblivion in such a ocean that the right to information will be, rendered to insignificance. So, to start with, I will quote Abraham Lincoln. Quote, "No man is good enough to govern another man without the other's consent." The Constitution is a social contract, and it provides you the source of power as well as the aims and objectives to be achieved through this. And the right to information, of course, we will discuss later on, is nothing but a facet of right to freedom of speech and expression enshrined under Article 19(1)(a) of the Constitution. Next slide. In the Right to Information Act, we will discuss the statement of objects and reasons, and then important definitions. The information, what is information, from where it can be sought, and obligations of various public authorities, exemptions, mechanisms, powers, and functions, and other miscellaneous provisions. Next. A statement of objects and reasons. In the RTI, if I summarize, there are only 4 or 5 elements. One is the citizen. Another, the public authority. Third one is it promotes transparency and accountability. Being a democratic country, we have to resolve the conflict between the information to be disclosed so as to bring transparency and accountability. At the same time, balance the preservation of confidentiality and sensitivity of information. Whereas the Constitution of India has established a democratic republic, and whereas democracy requires an informed citizenry and transparency of information, which are vital to its functioning and also to contain corruption and to hold government and their instrumentalities accountable to the government. And whereas revelation of information in actual practice is likely to conflict with other public functions, including efficiency of the operation of the government, efficient utilization of scarce resources, and preservation of confidentiality and sensitive information. And whereas it is necessary to harmonize these conflicting interests and while preserving the paramountcy of the democratic ideal, this act has been discussed. Next slide. Definitions. I would like to dwell upon only on the three definitions. There may be other definitions also, but the most important definitions are information, public authority, and right to information. I would like to read it before I discuss, as it has been provided. Information means any material in any form, including records, documents, memos, emails, opinions, advices, press release, circulars, orders, logbooks, contracts, reports, papers, samples, models, data material held in any electronic form and information relating to any private body which can be accessed by a public authority under any other law for the time being enforced. I'm reading it out to make it clear. Still, everybody thinks that under the information they can ask any questions, but we will discuss it is not so. It appears that advice they can ask, but later on I will discuss, just for making it clarity in the concept, is the obligation of the public authority is neither to become a teacher, nor to become a counsel or advocate, nor to become a cashier, and nor to open an inquiry office. Though while we are reading, it appears that everything can be asked for. What is indirectly is the meaning when it is in a material form, means whatever document is there, you can ask for a copy of that document. Neither you can ask for interpretation, nor you can ask for any reason, nor you can ask for any thing behind the decision. In the decision-making process, notice portion or any correspondence, if it exists, can be. But intention is not to correct, not to correct, and not to create problems. Now, public authority is a very, very important point in the RTI. Those who are the students of law, or those who are studied, stayed under Article 12 of the Constitution, they will understand how the definition of the state has gone material change. that was incorporated as it is during this RTI Act under the definition of public authority. That's a long, long history. And I would say initially universities was held to be not the state. Then there were some decisions, even LICs were not held as the state. Even CSIR, the registered society, was not held as a state. Likewise, ICR, the engineering colleges is all. It's a history. But later on, subsequently, they evolved certain principles as to whether substantially finance, as to whether it was the control of the government, as to whether they were discharging the public functions. Then they were brought in by way of law made by the Supreme Court as the public authorities. And whatever journey we had traveled all these years has been provided in the definition of the public authority. So for the benefit and clarity, I would like to read it, then I will make what the important points of this thing, which sometimes we miss it simply. Public authority means any authority or body or institution of self-government established or constituted by or under the Constitution. Number two, by other law made by Parliament. By any other law made by state legislature. By notifications issued or order made by the appropriate government and includes body owned, controlled or substantially financed, non-government organizations substantially financed directly or indirectly by funds provided by the appropriate government. So this is the definition. Now I make the little distinction. If you see the institutions of self-government established or contained in the first part is by or under the Constitution. But this under the Constitution is missing in subsequent clauses, like by any other law made by Parliament, by any other law made by the legislature. So it makes a distinction. Initially, if time permits, we will discuss little details. But here, I want to make a distinction here that the draftsmen who are sitting in the law ministry, they discuss, each para, each comma, each sentence, every word, and they tell which is appropriate. So when by or under the Constitution, the public authority becomes the public authority. But under the law made, like societies registration are under the Societies Registration Act. Now, there may be authorities which are by the law made by the state legislature or by the Parliament, but they will not become the public authorities in this because they are under the law. Then other conditions will have to be fulfilled before that is declared as a public authority. Some of the examples I will give you, like at one point of time, the BCCI was held as the public authority by the CIC. That already is state, still it is has not achieved any final. Another one was the BCCI. Another one, very important. I will tell you later on. So these are some of the organizations which may be by any law made by the state legislature or Parliament, but these may not be under the law. One is constituted by the law, one is by the law. So if there is a registration, unless the other conditions are fulfilled, either the substantially financed or you control, these cannot be declared public. And this becomes important. Why holding public authority is important? Because the right is against the public authority. You cannot ask any, private person provide this. This has been only, number one, by the citizen, available to the citizen, and against the public. And third, definition is very important. Sometimes there is a gray area in this also. What information can be claimed as a matter of right and what may. So, if you see, no right is absolute. Only the rights, there is a saying, your freedom to move your arm stops where my nose begins. So it is like that. So reasonable restrictions are envisaged. Even in all the rights, all fundamental rights. This is a statutory right. Even the right to life and personal liberty can be curtailed by law made by parliament through something like punishment, like other means. So exemptions have been provided. Next slide we will discuss. So, no, we will discuss that also. Exemptions we will come later. See, the right to information is what is not exempted. Okay, so information and obligations. This is the crux. In any act of parliament, there are two parts. One is the preliminary, and the other one is the functional part. Functional part means that actual provisions of getting the information, providing the information, putting obligations upon this, and how this can be exercised, these have been provided in this. That is the section 3, 4, 5, 6, 7. These are the sections. We have discussed the citizen, that it is available to the citizens. But what about the companies? They are not citizens, but they are legal persons. So I will discuss this issue was discussed by the Supreme Court in the matter of R.C. Cooper versus Union of India, the bank nationalization case. The directors, those who were the owners, but the directors, the bank nationalization took place and they filed their petitions that their rights have done away. So their issue was, you are not citizens. No, we are citizens, but the rights have been taken away of the company. So the Supreme Court very beautifully said, the state action may impair the rights of citizens or individuals, but may not impair the rights of the company. State action may impair the rights of a company, but may not impair the rights of individual, or there may be situation where the state action impairs the right of an individual and the right of the company. So if somebody's right has been impaired, and you are taking over a company without hearing the person whose rights have been impaired, then they brought out that anybody, whosoever is authorized, whosoever has a right in that, can claim, can file the petition. So under RTIR, we have been following the principle. If information is asked about a company, and the person who is authorized or is sought on behalf of the company, then the authorized person can make an application and he will be treated as a citizen. Citizen claiming and we are allowed. This is the difference. Other one more case I would like to discuss. You know, there are certain preventive. The law says, subject to other provisions of the act, every citizen is entitled to blah blah. This. So that has been discussed by the Supreme Court in very important preventive legislation. Constitution, Article 22 says that anticipatory disclosure is not allowed, but RTI says notwithstanding anything under Section 22. So they have made a harmonious construction of this. And there is another case also where somebody asked for the records of the courts. They have said that whether the rules of the High Court or the Supreme Court will prevail or the RTI will. So subsequently, it has been held that the High Court rules will give way, but at the same time, harmonious construction has to be given. So in this case, because the right, the provision is flowing from the Constitution, they said that RTI, under RTI, you cannot get whatever the Constitution is. Likewise, when the High Court provides a procedure, that procedure will have to be followed. Now, as regards next point, obligations, under Section 4 of the RTI Act, every public authority has been mandated to maintain the records in such a manner and indexed so that it can be easily retrieved, and it should be transmitted to every local offices, whereas the local PIOs and other officers could get that information and provide it to the information seeker. There are a number of things, whatever can be disclosed, that should be disclosed and put in public domain, that is the obligation. Then the question comes about the designation of the PIO. There was a mandate within 100 days of coming into existence with the Act. Every organization was supposed to notify the public information officers, either in the states or in the central. Then information is to be sought, it should be an application in writing, and if somebody is illiterate, there is an obligation of the RTI to help the applicant to put it in writing, and that obligation is there. Initially, there was a lot of resistance from the public authorities, the officers there. Now, I think now they have understood that this is also a necessary event which you have to live with. Otherwise, you have to explain it to the CIC or to the higher authorities or to the courts, and that's why nowadays people are trying to, public officers, they are trying to help and provide the information whatever is needed. And today, I would like to, while I discuss in the way forward, I would like to even highlight, not only for the public information officers, there is a need to train the RTI seekers how to write, how and what they should do and what they should not. Then there are timelines, 30 days, 6 days, then the 90 days appeals and all. I am not going to that aspect. The timelines have to be followed. That is the mandate of the RTI Act. And if somebody malafidely or by negligence doesn't provide the information sought within the scheduled period, then he is liable for penalty under the provisions of the RTI Act. Next. I was discussing, I was telling you that no right is absolute. There are certain reasonable restrictions. Our constitution is the only constitution where the reasonable word has been written in the constitution itself. In other constitutions or other jurisdictions, reasonableness has traveled a lot. See, if I discuss the definition of reasonableness or how we have arrived on this, that is called as the Wednesbury principles of reasonableness, then you will understand how, this reasonableness has, but in our constitution, because the constitution was prepared by very learned people after having studied the law of those times or the constitutions of those times, that's why our law is perfect. Of course, society changes, amendments are also there. So the reasonableness, the reasonable restrictions can be put on that right. And it is quite reasonable that the sovereignty, integrity, security of the nation has to be given primacy while disclosing information. Any information which invites the contempt of the court cannot be disclosed. Other things like the privilege of the parliament or the state legislature cannot be disclosed. Commercial confidence, state practices, secret IPRs, that also cannot be disclosed. It's damaging of the competitive position of any party. Then fiduciary relationship, the relationship which is, in confidence, like a doctor, patient, like this lawyer, like that. The advocate, the banks, maintaining the records of the customers. It cannot be without following the procedure mandated under section 11 of the RTI Act, that to seeking the consent for comment. Received in confidence, we receive so many information from foreign countries, and that there is a mandate that it will not be disclosed. If somebody, now our VC sir takes a decision, files something, maybe wants the personal where he lives, where he is there, or what are their events, so that can endanger the life of the VC sir. So it cannot be provided. So those who are filming through that information have to take care of this. Anything which is under investigation, that injudice case, and the cabinet papers, of course. For the information of the audience, I want to mention this cabinet papers issue came in the matter of, when the president rule was imposed in the UP and some of the other states, demolition or so there was a very famous case, SR Bombay versus Pune. And the Supreme Court asked for the cabinet paper, they claimed evidence. And at that time, the Supreme Court said, okay, don't give us the cabinet papers. They said, you give us all the relevant material on the basis of which the cabinet has taken a decision. Then we decide. So it was much more. So nowadays, it is much more. RTI has empowered to the citizens much more than, because they can ask for the relevant material or document on the basis of which any decision has been taken. And drawing the principles of Wednesbury principles of reasonableness, it is the reasonable is called a decision which a person of ordinary prudence will take. So that is much more under RTI and under this open government nowadays. Of course, personal information is right to privacy. those who are law people, they must be aware of the AS Puttaswamy case. There, where the Constitution bench has put the right to privacy on a higher pedestal as an ingredient of the right to life and personal liberty, and it cannot be disclosed. So 9 and 10, 11, there is a provision when intellectual property rights or trade market, trade secrets cannot be clear. If there is an exempted information and the information which can be severed in the section 10, this after severing the exempted one, the other one can be disclosed. And third party information after consultation, a decision will be taken to disclose that information or not to disclose. Next. Under the mechanism, there was prior to the Right to Information Act 2005, it was the Freedom of Information and 2002. Under that act, there was no mechanism. They have provided the right, and there was no appellate body like CIC. There was no penalty provisions. There was nothing. So there was a national advisory committee. They advised that it should be more progressive and it should contain certain mechanisms and should provide penalty provisions. That's why they came out, and the changes they made or they discussed the parliamentary committee was so drastic that they said we have to repeal this act. No. So that's why this new act came, and the Central Information Commission, which is was constituted, and the members, the chairman, is selected by a committee headed by the Prime Minister, wherein one of the ministers is the member of that committee and leader of the opposition. It's a very high level committee. And the powers and functions of the commission are, they can hear the appeals, they can investigate any matter, they can impose penalty. So the powers are also there, 250 rupees per day, up to maximum 25,000 can be imposed on the CPIOs. And appeals, of course, the first appeal lies with the first appellate authority. Then the second appeal lies to the Central Information Committee in the matter of the central government institution, and the State Information Commission where the states organizations are concerned. Penalties, as I mentioned, can be imposed when there is a malafide or willing, intentional sitting. So these provisions are there. With this problem, this mechanism, our RTI has become very strong, and they have a standard institution. Next slide. And the miscellaneous provisions, as I was telling, only when there is a malafide can be punished if somebody has not disclosed information. Maybe the PIO understands something differently in good faith. He should not be punished. And this good faith provision is available and protects all the government services. Overriding effect in the section 24 of the RTI Act, it has been provided, notwithstanding anything containing the law. So it's an override. But I was discussing the overriding has been now harmonized in such a manner so that so that there is a conflict is not there. There is a hierarchy of rights. So there is a constitutional right which is on a higher pedestal, like right to privacy is on a very higher pedestal. It is a constitutional right, and this is a statutory right. So the constitutional right will have a primacy over this. So harmonious construction has. Bar of jurisdiction. There is no appeal. People don't understand this. There is no appeal against the CIC or against the state information. There is only writ under 226, Article 226 before the High Court, and under Article 32 before the Supreme Court. And you know, there is a limited, jurisdiction under writ jurisdiction. It is not that they can substitute the wisdom of the commission. They can't. What they can do, writ means review only on 3 grounds. One is illegality, other one irrationality, third one is procedural impropriety. It is not that I am more wiser than you. No, it is something. If they did not have the jurisdiction, then they have passed the order. That is patent illegality. If there is a procedure, you have not provided fair hearing, you have not provided opportunity, or you have not followed the mandate of the act, then they can intervene. Or rationally, I was discussing the Pagnesbury principles of reasonableness, that will be a man of ordinary prudence would have not concluded or not reached on that decision. Then next. Now the constitution part. I've already discussed the freedom of information and some of the backgrounds, some of the historical backgrounds I would like to discuss. The freedom of access to information or right to information is a very old concept and practiced around the world since ancient times. The principles of access to information is hallmark of any democratic country. In 1766, Sweden passed the Freedom of Press Act, which is treated as the first case of empowering citizens with the aspect. The 65th plenary meeting of the United Nations General Assembly resolved that freedom of information is a fundamental human right and touchstone of all freedoms to which UN is consecrated. A 1995 report to the United Nations Commission on Human Rights elaborated, freedom will be bereft of all the effectiveness if the people have no access to information. In 2002, the Commonwealth nations law ministers specifically recognized that the right to access information was an important aspect of democratic accountability and promoted transparency and encouraged full participation of citizens in the democratic process. Further, as a party to the International Covenant on Civil and Political Rights, ICCPR, India is under an international obligation to effectively guarantee the right to information as per Article 19 of the ICCPR. This is the international ecosystem under which we were under an obligation, and we have come out with first Freedom of Information Act and then the Right to Information Act, as I have explained. Before I discuss the constitutional provisions, I will just quote few of the foreign jurists to highlight the importance of the freedom of information. In 1927, Louis Brandeis in Brittany versus California made a classic statement on freedom of speech in the context of US Constitution. Quote, those who won our independence believed that the final act of the freedom of speech was to make men free to develop their faculties. They believed liberty to be the secret of happiness and courage to be the secret of liberty. They believed that the freedom to think as you will and to speak as you think are means indispensable to the discovery and spread of political truth. That without free speech and assembly, discussion would be futile, that public discussion is a political duty, and this should be fundamental principle of the American government. Associated Press versus US. There was a Associated Press having several branches, several members. And the information which they were getting, they were sharing only to their own members, not to others. So there was a mandate to disclose something to the public. And this matter came before the Supreme Court in USA. And what Supreme Court has said while discussing the US Constitution, especially the First Amendment. It is the purpose of the First Amendment to preserve an uninhibited marketplace of ideas. Very important. Marketplace of ideas in which truth will ultimately prevail rather than to countenance monopolization of that market, whether it be by the government or by private license. In this background, before I come to the Constitution of India and discuss the Article 19, which has traveled from Ramesh Thapar through Maneka Gandhi in the latest UCL case. A lot of cases are there. I would like to read what Patanjali Shastri in 1950 said in the case of Ramesh Thapar versus Union of India. Quote, freedom of speech and the press lay at the foundation of all democratic organizations, for without free political discussions, no public education, so essential for the proper functioning of the process of popular government is possible. A freedom of speech or freedom of such amplitude might involve risk of abuse. But the framers of the Constitution may well have reflected with Madison, who was the leading spirit in the preparation of the First Amendment of the Federal Constitution, that it is better to leave a few of its obnoxious branches to their luxuriant growth than by pruning them away to endure the rigor of those yielding the proper fruits. Maybe there may be some danger. See, that is the objective of disclosing information. And now there is a myth which I want to clear today, that right to information came only with the Act of 2000. If you read the Constitution and Article 19, which gives so many freedoms one of them is the right to freedom of speech and expression. And in this case, which I have discussed, Rohit Thapar, for the first time, they have said, though the freedom of press is not expressed explicitly, but it is included in this. And disclosure was the rule whenever the Supreme Court used to say. And if I, discuss the cases, earlier there used to be a, sovereign immunity. What was the sovereign immunity? Which was derived from the common law, and there was a long, very old case that there was a ship wherein hundreds of people died in that ship. The name was the Thetis. That is called the Thetis case. And the UK court had decided that matter. And in that case, the minister used to file an affidavit that it is a privileged document. And the post, there is no written constitution. So the law used to prevail. Law is that when the sovereign is claiming privilege, it is sovereign immunity. You cannot ask. Our jurisdiction ends. So there used to be a sovereign immunity. And that sovereign immunity was demolished by the UK court itself when they claimed. In fact, their reasons were different because it involved, security, the sovereignty of the nation. If you tell there was a defect in the ship and it was made by that blah blah this company, so it may adversely affect their security. So that was okay. But in subsequently, all privileges used to be, claimed by the minister through an affidavit. In one of the affidavit, the minister claimed one of the poor policemen was dismissed, and they were claiming privilege not to disclose. So the court said, what is this? How can he be a danger to the security of the nation, a poor policeman? So they have demolished. And thereafter they brought in the public interest. So the rule came from there, and now in India, earlier there were, one chief minister was killed and some trial was there, some documents were there, some Punjab chief minister, I'm forgetting the information. So, person had fled abroad, he has gone abroad via Nepal, and there were some documents, they claimed privilege. At that time, sovereign immunity was invoked and they claimed it. Later on, you see R.K. Jain's case, S.P. Gupta's case, and even as S.R. Mumbai's case, and Mangal's case, and all those cases they have said. Now it is not sovereign immunity, it is the public interest immunity. You tell us, we document that we will see as to whether public interest demands disclosure or not. So now, here it is the public interest immunity which has come. And this was, right was already there from the very beginning, only it has passed through these stages. Earlier there was no mechanism. Way back in 1975, in the case of Rajnarayan versus Union of India, the Supreme Court has said, people of this country have a right to know every public act, everything that is done in a public way by their public functionaries. There are other judgments like Union of India versus Naveen Jindal, wherein that draft was vetted by me when I was in the law ministry. And I had objected because there were certain guidelines of the Home Ministry that the national flag can be hoisted only by the constitution, functionary flag to on certain occasions, and there were rules. In the evening, it has to be brought down, in the morning, so it has to be taken care of by this. There were elaborate rules. One Mr. Naveen Jindal, he had one industry in Madhya Pradesh, those was okay. So he hosted that national flag. The DM called him. Move it, how can only the district magistrate or functionaries, government functionaries can hoist this. Then he filed a case. And one of the bidding which was taken, very interesting. When I was abroad in US, I used to hoist flags, but in India, I cannot, hoist the national flag. He said, I'm expressing my nationalist patriotism. This is a sense of expression. This is my fundamental right? Here of the Constitution. How he stuck to the Supreme Court, and Supreme Court finally said yes. So this is, this is basically traveling in our Constitution, what was prohibited is now allowed. So there are so many other cases. Time permits, I will discuss, and those cases are loudspeakers, use of loudspeakers. They say have a right to silence, and right to silence is a right to speech and expression. Then likewise, for the first time, in the case of this matter, Cricket Association of Bengal versus Union of, for the first time, categorically, the Supreme Court has said the right to freedom of speech and expression includes right to be informed. There was a cricket match, and the organizers had outsourced it to some other foreign, broadcasters, and Doordarshan did not have the right, and it was not available to viewers. Somebody filed a case, said they were right, compromise and blah blah blah. In that case, it was very categorically said that right to information, the freedom of speech and expression includes the right to know, to have information. I think why the previous year method, a lot of election matters, it has been said that everybody has to declare an incident. Then the parliament came out with a law, if you remember, that nobody will be asked to give more than whatever is mandated by the government or by the commission, election commission. That was also struck down representation of people. In likewise, there are so many other cases based on this. We will not go into detail. Next. Way forward. There. In this, we will discuss very practical aspects. For the CBIOs and for general persons who are the information seekers. Sometimes they don't make a distinction as to whether they are raising a query, whether they are asking the information to be deleted, or they are asking something which is not in the custody of the public. I'm liable only for that, whatever is with me. If something is in the JNU, they are asking for it. It happens. Then again, there is a, obligation you transfer it. There are now judgments that if you are filing, it is not obligatory. Why should somebody be burdened with the transfer? But if it is within the department, for example, one CPIO is IGNOU, and it pertains to other, it is expected that it should be transferred. Other few judgments have been, hallmarks on the right to information. One has been, as I discussed, on these public authorities like BCCI, like there is one very important matter that is the Allah Palam. Allah Palam matter, there was one society registered under the Kerala Society Registration Act. And there was a notification wherein it was said that all the societies, there was one Mundu society will be under this RTI and they will be public authority. There was a notification by the government of Kerala. And it was decided in favor of the circular and it goes to the High Court and so. Finally, it reached in the Supreme Court and Supreme Court has made a distinction, what I was referring to. By or under the Constitution, but when it is the state or the parliament, by the parliament. So they have said it is not that everything which is registered is a public authority. The parameters are whether it is constituted by the government or by an act of parliament, or it is funded, substantially funded by the government, or there is a control, or there are functions of the government. So these were some of the aspects which were considered, and the Supreme Court finally said it's not applicable. So the BCCI or the BCCI was decided prior to that Allah Palam, and that has been decided. And there is another matter that was, they are political parties, very important. The CIC had said that it's a political party, state, funded, blah, blah. Both the judgments are now state, and these are the gray areas. But frankly speaking, some of the organizations like public sector banks, like some of the companies, government companies, which have 51 and above share of the government, these are all public authorities, and we are holding so. This is something which I would like to just highlight. Other cases can discuss later on. And next, I think that. Thank you very much. for giving me this opportunity.
Thank you so much. Indeed, it was a very informative session and very right you said that the right was already there in Article 19. It was only made implemented by the act and we got the mechanism of it. Now, I would request our Honorable Vice Chancellor, Sir Shri Professor Nageshwar Rao sir, for the presentation.
First of all, I congratulate you all on the eve of this Constitution Day. The Bible, Gita, or a Quran to us. And it's a momentous occasion to have with us Suresh Chandraji, Information Commissioner, PIC, New Delhi. The way he articulated the entire theme, it is lucid and you all can comprehend also easily. Most of the critical issues, the way he explained, they clearly tell us that such an important legislation which talks about our right to information, this can be understood by all of us so simple way and grasped to with a number of case studies also. Right to information. We are conscious about our rights. And we try to collect the information also. But what is that information? He clearly told us. And in the act itself, it clearly says, information is available with us. If it is not available, we should not create the information. And in most of the cases when we receive the questions, the queries, we want that the information needs to be given. And in some cases when we answer also, we also try to create the information, to create extra information. That is the crux which he told to all of us. Public authority, what is public authority? And what is the exemption? Sometimes we quote the wrong exemption. And those exemptions, they should not be stated in our response also. When we are saying that we are replying to a information query coming under right to information act. Further, he also clarified that the information PIOs who have been created for the purpose, how they should respond and what will be their liability. The last 7 to 8 sections, you'll find that they are almost there in almost all the enactments. Actions taken in good faith, they're always there. That's always there. Appropriate government. This word you'll find it almost all the enactments. It may be state government, it may be the central government. For central government organizations, the central government can formulate the rule. And in case of the state government will prepare the rule. Penalties, the exemption, because if you look at any enactment, that is the beauty of the Constitution. The crux of any enactment you will find in 4 or 5 main sections, except the Constitution of India. Otherwise, all the enactments which you see, in most of the cases you will find the Payment of Wages Act is there, Minimum Wages Act is there, Trade Unions Act is there. Look at it. There is a structure. And the last 7 to 8 points which is narrated here is just right people. They are almost common to all those acts. And that we derive from our Constitution. And therefore, we are today to sit here to look into the basics of our Constitution. And he rightly chosen the 2 different areas. The basic, the structure of the Constitution. It gives the rights, fundamental rights. And there are directive principles of state policy also. Both are very careful. Because the Constitution clearly talks about these 2. And every right, it has got the exceptions on. Because absolute rights they cannot be given. That word is also emphasized clearly to all of us. Sir, you enlightened all of us in such a simple way, because most of us are the giving the information as PIUs. But still we get confused when some queries and questions they have been raised on the right to information, then how to respond to it. Your clarity there that has enhanced all of us, the knowledge to present the thing and also respond to those things. And that is the purpose of having this Constitution Day celebration today. Now the Constitution document, the replica is available to most of us also. It has been made available last year. And Puneet ji, last time also it has given to us also. And I have received it from Parliament also, was very popular. So earlier this was kept as a confidential document. People were not knowing about it, what is the Constitution. It is the Gita to all. That is what I said in the beginning. The basics, the framework of entire country, the social relationship, the political relationship, the legal relationship. Everything is clear with that Gita which is Gita. So it is not to be read only by the professor of law. We all should know, we all should understand. Because they tell us the rights, the fundamental rights. And you see that the constitutional amendments, they have taken place only at that stage. And that too in those areas which are not relevant to most of us. Because still the basic rights and directive principles of state policy, they are the same as we got it way back when the Constitution it was being enforced. Sir, we welcome you and we all were enlightened by your clarity of expressing those difficult things with respect to a theme which is quite relevant to all. On behalf of the university, we express our gratefulness to you because before coming over here, I was just asking the background so that I can also find some sort of similarity with him. But somehow we could find that we are from distant places. From Rajasthan, I am from, I don't know from where. So he was presuming that I am from Haryana or some other place. Then from UP. And then finally I said I am from Andhra. So you see that this is again the beauty of the Constitution. It talks about the citizen. It talks about the individual. And our rights, the fundamental rights. And how those rights get exercised. And now that is in corresponding with the duties also. Honorable Prime Minister has also talked about the duty. So we must be duty conscious. Thank you very much. Thank you.
Thank you so much, sir. You explained that with every right we have, and unless and until we follow the duty, we are not entitled to get that right. With this, we. This our program has come to its end. It was a very enlightening session. I would like to thank all the esteemed guests.
Thanks, sir.
Yes, sir. Yes. I was about calling for them. I would request Mr. Alok Sobe, sir, Registrar, to come up on the dais and give that.
विश्वविद्यालय के नाम को बधाई देना चाहूंगा कि इन्होंने ड्राइव स्टॉर्मिंग जो सेशन आयोजित किया है इसका टॉपिक मीनिंगफुल चैलेंजिंग और डे टू डे हम जो प्रॉब्लम फेस करते हैं वो उससे संबंधित है और उससे भी ऊपर मैं हमारे आज के मुख्य अतिथि सुरेश चंद्र जी, सूचना आयुक्त, केंद्रीय सूचना आयोग के प्रति भी आभार व्यक्त करता हूँ कि उन्होंने हमारे बहुत सारे डाउट्स लगभग क्लियर कर दिए हैं जो हम डे टू डे फेस करते हैं। हम में से बहुत सारे लोग पीआईओ हैं, लीड अधिकारी हैं, तो हम लोग को एक ही उसका जो सेक्शन है वही हमारे आसपास घूमता है, वो सेक्शन 8 कि हम कौन सी सूचना देने के लिए मजबूर हैं और कौन सी सूचना हमको देना चाहिए। कई बार ऐसे कॉन्फ्लिक्ट आते भी हैं। फॉर एग्जाम्पल मैं आपको बताऊं, जैसे सर ने बहुत क्लियर कर कहा कि थर्ड पार्टी इंफॉर्मेशन विदाउट थर्ड पार्टी कंसेंट हमको नहीं देना चाहिए। उसमें इश्यूज ये आते हैं कि कई बार हम यूनिवर्सिटी एप्लीकेशन करते हैं या कई बार हम लोग मेडिकल कॉलेजों की फीस फिक्स करते थे, तो वहां से पूरी जानकारी लेते थे, तो कॉलेज के प्रोफेसर हमारे से आरटीआई में जानकारी मांगते थे। साहब आपको मेडिकल कॉलेज ने ये बताया कि हमको 2 लाख रुपए तनख्वाह दी जा रही है, लेकिन वो तो 1 ही लाख दे रहे हैं, हमको आप आरटीआई में जानकारी उपलब्ध कराएं। कई बार जेन्युइन भी लगता था उनकी प्रॉब्लम कि भाई उनके नाम पे बाहर कुछ ज्यादा है। फिर हमने इंस्टीट्यूट से चाही परमिशन के साथ, ये आपका जो डेटा है दे सकते हैं क्या, तो उन्होंने कहा नहीं साहब मत दीजिए। तो कहीं ना कहीं हमने कहा भाई हमने तो कारण बताया, आपकी कारण बता दीजिए। तो उनका कारण ये था, बोले साहब आप उनको जानकारी दे देंगे, जानकारी उनको नहीं चाहिए, दूसरे प्राइवेट मेडिकल कॉलेज को चाहिए, वो कहेगा हम 50,000 और देते हैं और हमारे एक्सपर्ट को ले जाएगा, इसलिए आप जानकारी मत दीजिए। तो ऐसे इश्यूज हमको डे टू डे फेस करना पड़ते हैं। कई बार ये होता है सर कि हम लोगों को बहुत वेग इंफॉर्मेशन मांगते हैं, मतलब कई बार उन्हें 5-5 हजार पेज फोटो कॉपी करा के दिए, ये एक तरीके का वेस्टेज भी होता है स्टेशनरी का। तो इसमें मेरा एक अनुरोध था कि अगर कहीं ऐसा हो सके कि क्या हम सॉफ्ट कॉपी में भी अगर देने का कोई प्रावधान होए, तो हम बहुत सारी स्टेशनरी प्रोटेक्ट कर सकते हैं, जिससे कहीं ना कहीं हमारा एनवायरनमेंट प्रोटेक्शन भी रहता है, हमारे पेड़ बचते हैं। तो एक ये हमारी रिक्वेस्ट के इस डायरेक्शन में भी अगर कुछ इसमें विचार हो या कोई आपके पास जानकारी हो तो हम लोग को एनलाइटन इसमें भी करें। तीसरी चीज ये होती है कि जब हमने ये वेग इन्फॉर्मेशन कुछ आरटीआई एक्टिविस्ट से पूछा कि भाई आप क्यों मांगते हैं, तो उनका ये कहना रहता है कि हम इसलिए मांगते हैं कि जो हम जानकारी चाह रहे हैं अगर सिर्फ वही मांगेंगे तो हो सकता है जिससे हम चाह रहे हैं वो उसमें से कुछ हेर फेर करे, तो हम एक वेग इन्फॉर्मेशन बहुत सारी मांग लेते हैं और उसमें से हम छांट लेते हैं काम का। तो ऐसे डे टू डे, लेकिन सिर्फ इतनी सी कंसेप्ट के पीछे हम बहुत बड़ा लॉस करते हैं। हमको भी बहुत ज्यादा दिक्कत होती है कि उतना सारा मटेरियल कई बार सर ऐसी वेग इन्फॉर्मेशन आती है कि जस्ट फ्रॉम इंसेप्शन आपके पास इस संबंध में जितने भी करस्पॉन्डेंस है आप दे दीजिए। अब ऐसी स्थिति में भी हमारे पास ये क्वेश्चन नहीं रहता कि हम उससे क्या बोल के उसको मना करें, क्योंकि ये भी अलाउ है। तो बहुत सारी चीजें इस मामले में ऐसी रहती है कि जहां हम लोग भी अटक जाते हैं और वो 8 सेक्शन का ही सहारा लेने की कोशिश करते हैं। पर्सनल इंफॉर्मेशन के बारे में भी कई बार वो व्यक्तिगत इंफॉर्मेशन मांगते हैं दूसरे की, कई बार मांगते हैं, तो हम उनसे ये अगर कहते हैं सर उससे आपका क्या रिलेशन, तो नेचुरली आजकल तो आरटीआई एक्टिविस्ट हैं, उनका रिलेशन होना हो कहते हैं कि हम पब्लिक इंटरेस्ट में मांग रहे हैं, तो वहां पे भी कई बार हम लोगों के सामने प्रश्न चिन्ह खड़ा हो जाता है। फिर भी मैं इस मामले में आपसे जरूर कहूंगा कि आज आपने हमारे बहुत सारे प्रश्नों के उत्तर दिए और हम लोग को और ऐसी अथॉरिटी से हमको उत्तर मिले हैं कि हमको और कहीं रेफरेंस लेने की जरूरत नहीं है, फाइनल अथॉरिटी है। और इसी के आगे मैं हमारे माननीय कुलपति प्रोफेसर नागेश्वर राव जी का भी बहुत बहुत धन्यवाद दूंगा। आज उनका बिजी शेड्यूल था, लेकिन उसके बाद भी उन्होंने हमारे बीच में आए और इस कार्यक्रम की शोभा बढ़ाई और हमको फर्दर एनलाइटन किया। उसी चीज को उन्होंने बेटर अंडरस्टैंड करके फिर से एक्सप्रेस किया जो सर ने हमको बताया था। मैं उनका बहुत बहुत धन्यवाद देता हूँ। उनका मार्गदर्शन हर जगह रहता है और हर इस तरीके के कोई भी आयोजन में उनकी ओर से कभी ना रहती ही नहीं है, हमेशा उनके मार्गदर्शन में बहुत अच्छी चीजें होती हैं। इसके बाद में हमारे बीच में जितने भी कुलपति उपस्थित हैं, प्रोफेसर सत्यकांत साहब, प्रोफेसर मोहपात्रा जी, कानीवाल मैडम और सुमित्रा मैडम, उनका भी बहुत आभार व्यक्त करता हूँ कि वो आए और उन्होंने इस पर्टिकुलर सेशन की शोभा बढ़ाई। यहाँ उपस्थित जितने भी डायरेक्टर्स हैं, जितने भी प्रोफेसर्स हैं, जितने भी अधिकारी हैं जो यहाँ उपस्थित हुए, जो आरटीआई, देखिए आरटीआई के कहीं ना कहीं टेबल के इस तरफ है और कहीं ना कहीं हमें लाइन में जुड़ना ही पड़ता है, अगर हम कहीं सरकारी उसमें उपक्रम में काम कर रहे हैं। तो मैं उन्होंने भी इस चीज को पूरा इंटरेस्ट लिया, मैं उनका भी बहुत ज्यादा आभार व्यक्त करता हूँ। और उसके बाद मैं हमारे यहाँ के जो सुरक्षा अधिकारी हैं वो हमारे हर आजकल प्रोग्राम में अपनी ओर से अपनी सुरक्षा की टीम से हर प्रोग्राम को बहुत अच्छा बनाने का प्रयास करते हैं, मैं उनका भी बहुत बहुत धन्यवाद देता हूँ। और इसी के साथ मैं आप सभी को विशेष रूप से लॉ डिपार्टमेंट को ये जरूर कहना चाहूंगा कि मैडम दिस इज नॉट द एंड। भले ही कॉन्स्टिट्यूशन डे एक दिन होता है, लेकिन कहीं ना कहीं हम इससे पूरे साल जुड़े रहते हैं, हर वक्त जुड़े रहते हैं एज ए रिस्पॉन्सिबल सिटीजन। तो आप इसको और कराएं, और भी ऐसे इश्यूज हैं जिसमें आप सेशन जरूर कराएं जो हम सभी के लिए बहुत जरूरी है, लाइक इंटेलेक्चुअल प्रॉपर्टी राइट्स हो गया, और आपका कुछ और भी ऐसे इश्यूज हैं जिसके बारे में आप हम लोग को एनलाइटन करें, क्योंकि लॉ के बिना आजकल लाइफ बहुत कठिन होती है अगर लॉ की जानकारी नहीं। पढ़े लिखे होने का आज की डेट में मतलब यही है कि आपको कानून की थोड़ी बहुत जानकारी होनी चाहिए। इसके साथ ही बहुत बहुत धन्यवाद आप सभी को इस फंक्शन को सफल बनाने के लिए। बहुत बहुत
I request everyone to stand up for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता। पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य।
एक दो प्रश्न